This is a significant development in two distinct but high-profile areas of federal investigation. We have a massive release of documentation regarding the Jeffrey Epstein inquiry, and we have a forensic analysis of audio evidence involving Donald Trump. To understand the full scope of what is happening, we need to break this down piece by piece, looking at the implications of what has been released, and perhaps more importantly, what is being preserved for potential future adjudication. Let's begin with the data dump coming out of the Department of Justice. We are looking at a historic release of information. The DOJ has made public more than 3 million additional pages of documents tied to its long-running investigation into Jeffrey Epstein. To put that in perspective, this is the single largest batch of files ever shared regarding this specific case. These aren't just administrative papers. They shed new light on the intricate web of relationships Epstein maintained with prominent figures across the United States and the United Kingdom. Now, whenever you deal with a release of this magnitude involving sensitive crimes, the immediate concern is the privacy and safety of the survivors. The Department of Justice has been very specific about their redaction protocol here. They have scrubbed images of all women involved, with the notable exception of Epstein's associate, Ghislaine Maxwell. The goal is to strictly protect the identities of survivors. Furthermore, they have withheld documents that contain personal medical information, as well as any depictions of child sexual abuse or materials showing death or violence. This is a critical distinction. This is a transparency release, but it is not an unfiltered dump. Officials have indicated that this is likely the final major release of the Epstein files. This is interesting because federal prosecutors initially identified nearly 6 million pages that complied with the Epstein Files Transparency Act. So we are seeing a massive amount of data, but perhaps not the totality of what was originally flagged. Now, I want to pivot to the second, and legally speaking, more volatile issue at hand. We need to talk about audio evidence. In the legal world, there is a hierarchy of evidence. Witness testimony is good, but witnesses can be cross-examined. Their memories can fade. Documents are strong, but they can be open to interpretation regarding who wrote them or who read them. But audio recordings of a defendant's own voice are often considered the apex of evidentiary power, and that is exactly what prosecutors possess regarding Donald Trump. We aren't talking about leaked rumors or secondhand hearsay. We are talking about high-fidelity audio recordings that have been heard by grand juries, cited in federal indictments, and exist as permanent forensic evidence. Let's analyze the first key recording, often referred to as the Bedminster tape. This dates back to July 2021. The setting is Donald Trump's golf club in New Jersey. He is meeting with individuals who are working on a memoir for Mark Meadows. Now, to understand the gravity of this, you have to look at the specific legal elements of mishandling classified information. The government usually has to prove willfulness, that the person knew what they were doing was wrong. On this recording, Donald Trump is discussing a Pentagon war plan regarding a potential attack on Iran. This is highly classified, sensitive material. On the tape, you hear him showing it off. But here is the moment that legal experts call the smoking gun. Mr. Trump says quite clearly, "As president, I could have declassified it." He then follows that up with, "Now I can't." And finally, "This is still a secret." Why does that specific sequence of sentences matter so much? Because it dismantles the primary defense strategy. For a long time, the argument from Mr. Trump's legal team has been that he had a standing order to declassify documents, or that he believed he had the authority to declassify them simply by taking them. But on the tape, in his own voice, he is admitting three things simultaneously. First, he admits he knows how the declassification process works. Second, he admits he is no longer the president and therefore lacks that authority. And third, he admits that the document in his hand is, in fact, still a secret. When you have a defendant admitting on tape that they are knowingly holding classified material that they knowingly cannot declassify, that is what prosecutors call intent. It removes the possibility of claiming it was an accident or a misunderstanding. It is a confession of knowledge captured on audio. Then we have to look at the second piece of audio evidence, the Georgia call from January 2021. This is the conversation with Brad Raffensperger, the Secretary of State for Georgia. This call is over an hour long, and it documents a relentless pressure campaign. But there is one specific sentence that prosecutors focus on, and we need to understand the math behind it to understand the crime. On the recording, Donald Trump tells the Secretary of State to find 11,180 votes. Now, why that number? Why not just ask him to check the ballots or investigate fraud? Because 11,780 was exactly one vote more than the margin he was losing by. He wasn't asking for an investigation. He was asking for a specific arithmetic result that would flip the state. When Raffensperger pushes back, citing accurate data, the tone shifts. Mr. Trump warns him that he is taking a big risk and hints at criminal liability for the Secretary of State. In the eyes of legal experts, this moves the conversation from a political grievance to criminal solicitation. It is an attempt to coerce a state official into altering certified election results through threats and pressure. Again, this is not a witness saying, "Trump told me to do this." This is the recording itself. It acts as a witness that cannot be impeached. There are other recordings as well, audio from private fundraisers where strategies are discussed that experts say cross legal lines. All of this is preserved. It is sitting in the evidence locker. So, the natural question you might be asking is, if this evidence is so overwhelming, if it is proof beyond reasonable doubt, as prosecutors have argued, why hasn't it been played in open court? Why hasn't a jury heard it? The answer lies in the complex machinery of the American legal system and the unique protections afforded to the presidency. The case regarding the classified documents was dismissed by the judge in Florida, not because the evidence was weak, but on a procedural ruling regarding the validity of the special counsel's appointment. That dismissal is subject to appeal, but appeals take time. Meanwhile, the Georgia case has been bogged down in procedural challenges regarding the district attorney. Furthermore, we run into the constitutional reality of the presidency itself. Department of Justice policy has long held that a sitting president cannot be prosecuted. This creates a form of legal stasis. Even though the evidence was collected, even though indictments were issued, the return of Donald Trump to the highest office in the land essentially hits the pause button on federal prosecutions. However, and this is the crucial point for anyone analyzing the long-term history of this era, paused does not mean erased. Audio evidence is permanent. It does not degrade like a witness's memory. It does not change its story under cross-examination. These recordings exist. They have been authenticated. Prosecutors have verified they are real. They establish a permanent historical record of conduct. This presents a unique scenario. Mr. Trump's legal strategy has largely been one of delay. The goal was to push these trials past the election, to use the immunity of the office to shield himself from the courtroom. And politically, that strategy has worked. He is not currently sitting in a defendant's chair. But the existence of these tapes creates a reality that cannot be spun. In a typical trial, a defense attorney tries to offer an alternative explanation for the evidence. But how do you explain away the client's own voice? If a jury were to hear the Bedminster tape and then hear a defense attorney argue that Mr. Trump thought the documents were declassified, the jury would see an immediate, irreconcilable contradiction. The tape proves the defense is false. This is why these recordings are described as a nightmare for the defense. They restrict what arguments can be made. You cannot argue ignorance when the tape proves knowledge. You cannot argue you were just asking questions about election integrity when the tape shows you demanding a specific vote count to win. Even without a trial occurring right now, these recordings serve a function. They are available to the public. They are available to historians. They provide a window into the intent and operations of Donald Trump that no press release or spokesperson can obscure. We are in a situation where the legal system's procedural delays have prevented a criminal verdict, but the evidence itself offers a historical verdict. The prosecutors who built these cases, specifically the special counsel's office, asserted that they had sufficient evidence to secure a conviction. When they say that, they are relying heavily on these tapes. They are saying that if 12 jurors sat in a room and listened to Donald Trump speak, the result would be a conviction. The fact that the trial is not happening doesn't change the content of the tapes. It simply changes the venue in which they are heard, from a courtroom to the court of public opinion and historical record. To summarize the situation, we have a massive release of documents from the Epstein files, closing a chapter on that investigation with a final, large-scale transparency effort. Simultaneously, we have the enduring presence of the Trump recordings. These audio files serve as immutable proof of intent and conduct regarding both national security secrets and election interference. While political victories and procedural maneuvering have successfully kept these recordings from being the centerpiece of a criminal trial for the time being, they remain arguably the most potent evidence ever collected against a president. They are the voice of the man himself, cutting through the spin, admitting to the very things prosecutors spent years investigating. They are preserved, they are verified, and they are waiting, either for a future day in court or simply as the undeniable record of what actually transpired.